Good evening from Chicago, and thank you for joining us. I'm Rolnik. I'm a clinical professor of strategic management at the University of Chicago Booth School of Business, and one of the organizers of this conference series. Tonight, I'm happy to host a conversation over dinner with Assistant Attorney General Jonathan Kanter and the Chair of the Federal Trade Commission, Lina. Before we begin, please note we are on the record and live streaming, and we will also post this event video on the Stigler Center YouTube channel later. If you have questions for the speakers, we will address them in the last 50 minutes of this conversation. And as usual, the views expressed by guests are their own, not those of the Stigler Center or the University of Chicago. So I want to welcome to our conversation two of the most, arguably the most transformational regulators in the 21st century, Lina, Chair of the FTC, and Jonathan Kanter, Head of the Antitrust Division at the Department of Justice. So welcome, Lina and Jonathan. So it has been 7 years, yes, 7 years since we had Lina and Jonathan here at our inaugural Stigler Antitrust Conference. And of course, a lot has happened since then. But if I had to choose the most surprising change that we couldn't have expected 7 years ago, it would be that the topic of our conversation here tonight were previously considered to be very boring, fringe, and technical, even sometimes by academics. And those topics have now gained significant interest with many, many people. March of the same year, of 2017, I believe it was Judge Richard Posner that declared here in this room that antitrust is dead. Well, antitrust is not only alive today, alive and kicking, it's actually pretty cool. And how do I know that it's cool? It's so cool that Jon Stewart thinks that he can leverage it to get his primetime ratings back again by having Lina on the show. So what it means for us here this evening is that the audience of this conversation that we're going to have tonight is not only you, people here that are experts in antitrust, law, and economics, but the public at large. They are watching us live, and later maybe in short snippets, they will see it on social networks. That is, of course, if the social networks don't suppress it. So let me join you now. So after calling you the most transformational regulators in the US in the 21st century, I want to start by asking you, Lina and Jonathan, how did you transform the agencies that you lead? Lina, you're going to be in June 3 years in your job, and Jonathan, for you, it's somewhere like 2.5 years. So let's start with, tell us the transformation from your perspective, Lina.
Well, first of all, let me just say it's so terrific to be here, and thanks so much to Guy and Luigi and Stigler for convening such an important discussion. Stigler has just been at the forefront of helping not just capture the state of policy debate around these issues, but actually drive it forward. And partly it's been able to do so through just a commitment to open-mindedness and genuine curiosity and a focus on evidence-based discussion, which has just been so critical to make sure that We're revisiting assumptions that may be outdated and really mapping out an approach to the law and policy that's actually reflecting the reality of how markets are working. So just my thanks to you all for helping convene such an important set of discussions year after year. At the FTC, our focus has been on making sure we're enforcing the law in a way that's faithful to the tools that Congress has given us. B, updating those frameworks and tools where we need to make sure they're reflecting the reality of how businesses are operating and pursuing their strategies in the year 2024. And third, through making sure that we're regularly engaging and hearing from and learning from the public. And across each of these dimensions, we've really been focused on, first of all, just making sure that we are fully dusting off the tools that we need. And I would say for the first, 12 months, a lot of the focus was on making sure we were, doing things like issuing our new Section 5 policy statement, embarking on a journey to revise the merger guidelines, adopting new policies and processes, and really sharpening all of our tools. And the last, 18 months, we've just been in execution mode, continuing to sharpen those tools, but making sure that we're actually able to follow through. And so it's been an enormously exciting time, and in some ways it feels like the work is just beginning.
Thank you, Jonathan.
Yeah, let me echo Lina's thanks for having us, and also echo the importance of this conversation and the conversation that this conference and Stigler Center has been at the forefront of leading. I remember quite vividly that first conference, and it's remarkable to think about the conversation we're having today, the conversation that the public is having today, compared to where we were then. I remember, I was actually thinking as you were introducing us, I was the pleasure of being on one of those panels, and I remember saying at the time that our profession, the profession of antitrust lawyers and economists and professionals, was at risk of becoming irrelevant because the public was seeing a problem. The public was seeing a problem with corporate concentration. The public was seeing a world where they may not use the same vocabulary to describe antitrust, but they were concerned. And we were stuck in this bubble, in this insular bubble, with our exclusionary words and static models, while real people were suffering real harm. And I remember saying and thinking that we were at risk of becoming irrelevant, and we better get our act together as a profession, or we're going to be left behind. And so I think with a lot of hard work, we're getting our act together as a profession, and we are finally focusing on addressing modern problems in a forward-looking way. And that's, I think, a good segue into the transformation. I think first and foremost, we've really tried to instill a world where we start with, how do things work? How does competition work in this market? And so rather than trying to fit facts into models, we're starting with saying, how does competition in this market function? Forget if it's vertical or horizontal or two-sided or multi-sided. How does it work? And does the conduct or the merger that we're encountering threaten that competition? The answer is yes. Then we figure out how we want to address it, how we want to deal with it. And I think that shift to a focus on market realities, including broadening the disciplines that we rely on to help investigate and bring cases, has really transformed the way we approach enforcement. I think, like Lina mentioned, we're also going back to first principles. And first principles in antitrust is that competition is good. We like competition because it has a range of benefits that flow from lower prices, but also it affects our democracy. It affects our liberty. Why? Because we are a country that believes in opportunity, in access to markets, in diversity of viewpoints and ideas in a competitive economy helps elevate those principles.
Okay, so thank you for these opening answers, but I want you to be more specific if you can. So tell me first, Lina, and then Jonathan, which of your wins that you had in the last 3 years were the most important to you?
Well, I think a critical input across all of our work is the fact that we are closely engaging with and responding to the public. And that relates to the comments that both of you made, which is, one key catalyst for the transformation has been, in fact, the way that there had previously been a gap between how we were analyzing problems in the economy and how people were actually experiencing those. And so across the board, actually continuing to deeply engage with and learn from the public has been critical, in part because it helps inform how we do our work, how we pick our priorities, but also because it helps continue to build support for the transformation that has been underway, and make sure that we make clear to people that this reflects government in their corner, fighting for them, which is important when you think about the disillusionment that we've seen at various points with government, the sense that things are just not working, the sense that the outcomes in your life are not necessarily a reflection of your own hard work, but a reflection of arbitrary decisions that are being made by powerful entities far away. And so making sure just at a fundamental level that we are engaging with and learning from and hearing from the public is critical. And so the fact that we have seen that part of our work shift has actually been an enormous win, not just for, the next few months, the next few years, but it's actually going to be a critical input for the institutional durability of what we're doing. The fact that people are connecting the problems in their day-to-day lives with decisions that are being made in Washington, D.C., is a really critical set of feedback loops to make sure that these shifts are going to be in place for the long term. More generally, we've just been really thrilled with progress that we've been able to make, both when it comes to updating some of our tools and frameworks. I mentioned the Section 5 policy statement. The unfair methods of competition authority that the FTC has is existentially fundamental to why the institution was created. For many years, it had been somewhat dormant, and so we've been activating that, bringing cases based on that authority. Last year, we proposed a rule to eliminate non-compete clauses across the vast majority of employment contracts based on that authority. We were also really thrilled in partnership with the DOJ to put out revised merger guidelines, which reflects a lot of the first principles that we've been talking about. Fidelity to the underlying law, both the law that Congress wrote as well as the precedent on the books, fidelity to the realities of how competition is functioning today, and third, a lot of engagement with and feedback from the public. Over the course of that process, we got thousands of comments from the public, which is just, worlds of difference from prior iterations. And now that those have been finalized, we're continuing to bring some of our cases in a way that fully reflects the updates in those guidelines, be it, a more sophisticated set of understandings about how competition and digital platforms work, a more sophisticated set of understandings around how competition and labor markets work, a recognition of evolutions in certain types of business strategies, so the ways that you can have serial acquisitions, these roll-up plays, which, you may have a series of deals, each one of which may seem benign and fly under the radar, but in the aggregate, which can result in consolidation and roll-up of an entire market. We've also been really pleased with a whole set of important lawsuits that we've been able to file, be it a lawsuit against 2 pesticide giants that were engaging in pay-to-block schemes that ended up inflating the price that farmers were paying to the tune of billions of dollars, a lawsuit against Amazon, which plays an important gatekeeper role in the economy, but has now been abusing its monopoly power in ways that result in both shoppers paying more and sellers paying more, and a whole set of merger lawsuits as well. We also last year brought a lawsuit against a private equity company for architecting one of these roll-up schemes in Texas. They went out and bought up all the large anesthesiology providers in Texas and then hiked up prices importantly, in that case, we named not just the practice that did the roll-up, but also the private equity funds, because we think across our work, it's important to look upstream and make sure we're holding the actual decision makers to account.
Thank you, Jonathan.
Yeah, so I think it's important to not focus on any one specific matter, and I'll explain why. Because I think the body of work, and it's really across both agencies, speaks more to the progress I believe that we're making. I recently undertook an interesting exercise with my team where we took, without any commentary, just a list on one page, all the things that we've done over the last 2.5 or so years. And when you look at that in its totality, it's a very exciting picture. It makes me tired. I realize that we've been working really hard, but I'll give you examples. We talk about the cases that we've litigated and won, including not one but 2 airline mergers. The first time ever we litigated to block and successfully blocked airline mergers, blocking a book publisher merger based on a monopsony theory, harm to laborers. We have seen approximately 20 acquisitions abandoned in the face of either a lawsuit or an in-depth investigation. I can't overstate how important that is, the importance of deterrence and the importance of, rather than having these transactions harm competition, having them go away completely. That is a very important measure of success. We filed groundbreaking civil litigations around monopolization cases, including 2 very large tech companies, and we're litigating those cases in court. We have a case in the agriculture space where we're talking about protein prices. We have seen the first time ever a systematic enforcement of Section 8 of the Clayton Act and interlocking directorates. And as a result, we've had approximately 20 board resignations across a wide range of companies as a result of our Section 8 enforcement. We have brought groundbreaking criminal cases, including for the first time in over 45 years, a conviction for criminal monopolization. And then we got another one recently, and we're litigating a criminal monopolization case this fall. We also saw for the first time ever a divestiture, breakup of a company in order to resolve a criminal antitrust violation that resulted in the divestiture of pharmaceutical assets that were being fixed to a high price for consumers. And we required that company to give free pharmaceuticals to people in need. And so these are real results, and we have a whole range of convictions and plea agreements, including litigated trial victories. On the policy side, as Lina mentioned, we've been hard at work working with our colleagues at the FTC to probably undertake the most extensive overhaul of the merger guidelines ever, and one that focuses on fidelity of the law, focuses on market realities. And so we incorporate a lot of the traditional approaches to merger review. We have unilateral effects and coordinated effects, but we also talk about platform markets. We talk about entrenchment of market power. We talk about labor competition. We talk about serial acquisitions and roll-ups. These are real issues that we are confronting on a regular basis. We are bringing labor cases. We brought a successful resolution to a case that involved poultry processing plant workers, including $80 million in direct restitution back to those workers in a labor theory. We brought a labor case involving esports and got relief for esports competitors. We are seeing a very vast and extensive body of work. We've also, and this is really important, worked with the FTC and our counterparts throughout government to initiate a whole-of-government approach that the president has championed. And that whole-of-government approach has us working with the U.S. Department of Agriculture. And for the first time, to our knowledge ever, the United States Department of Justice brought not one but 2 Packers and Stockyards Act cases And we've worked alongside our colleagues at HHS and DOT and agencies across the country to focus on competition as a core value of our economic policy. And I'm really proud of that work. We've also been a leader on the international stage through our work at the OECD and the ICN, and have antitrust was invented in the United States. And as the inventors of antitrust, we have something to say about its future too. And we are always with a mind toward optimizing for U.S. law and U.S. citizens, making sure that we are taking up our role as leaders on the international stage.
Let's, for a brief time, go back a little bit from some history. So David Dayen, who has participated in many of the conferences here since we started, wrote right after the first conference that he thinks that a new movement is born, and later he called it the new Brandeis School. And of course, I know both of you are admirers and students of Brandeis.
Is it the new Brandeis or the new Chicago School?
We'll talk about that later. So do you feel that I'm trying to get you in hot water, you're trying to get me in hot water? Okay.
Turnabout's fair play.
So do you feel that you are applying Brandeis's ideas when you're enforcing the Sherman Act and the Clayton Act, Lina?
Look, we're law enforcers that are focused on being entirely faithful to the laws as Congress has written them. And, there's a rich history of precedent on the books, and we are close students of all of that precedent. There had been, moments, especially starting in the 1980s, where we dramatically veered off course. And enforcers decided that there were, provisions or statutes or precedent on the books that made them uncomfortable, that were no longer in fashion. And so they decided to really stop queuing and faithfully enforcing those provisions or the precedent on the book. And as an enforcer, that gives me a lot of discomfort. We are bound by the laws on the books, by the task that Congress has given us. And so that's why we've been going back to those first principles. I do think that across the board, one commitment of Brandeis was a devotion to understanding how things work in the real world. I mean, you read some of his opinions and they're just such deep expositions of the mechanics of how a particular contract was, functioning. And, I got my start in all of this as a business reporter. And so just the mechanics and just how stuff is really working in the real world is absolutely critical to make sure that we're not, perpetuating certain blind spots, that we're not just relying on stale theories or outdated assumptions, but we're actually doing our work and enforcing the law in a way that maps onto the reality of how businesses are operating, how competition is actually functioning. And so I would say Brandeis's commitment to reality is probably, a core principle throughout all of our work.
Jonathan?
I agree.
Okay, so let me move to one of the main subjects of tonight's discussion. So this year, in January of this year, for the first time, the participants at the World Economic Forum, they had a yearly survey about global risks. And for the first time since this survey has been running, the number one risk that executives, politicians, academics, experts all over the world said this is the most dangerous and risky phenomena in the world today is not climate change that took the first spot for years, but misinformation. What do you think?
It's a real problem and it's a real risk. The fact of the matter is, I'm an antitrust enforcer, so I'll try to stay in my lane and focus on antitrust enforcement. But for all those who think about the importance of output as the goal of antitrust, I would ask you to question: what do you think about increased output that leads to the spread of disinformation and misinformation, and even monetization of ads alongside that misinformation and disinformation. And so I think we have to take a step back and say, okay, these are economic realities that we confront, and markets function differently than they did 30 years ago. And we need to adjust our thinking to keep pace.
Lina?
Traditionally, we've had a news ecosystem, an environment that relied on dispersion and decentralization, and situations where you instead have gatekeepers that are consolidating control over who gets heard, who gets to speak, I think magnifies some of the risks that certain types of information are going to, win the day without real competition. For the FTC, we're really focused on commercial speech. And so we look at fraud and the way that some of these AI tools are enabling turbocharging of fraud, enabling, much more sophisticated scams that can be hyper-targeted to people based on their own personal, social media profiles, based on their own communities. And so those are some of the risks that we're focused on in terms of the turbocharging of fraud.
Okay, so let me try to be more specific. We are a decade, maybe more, into a world that much of the information and discourse is controlled by algorithm of 5 tech firms. And yet, we are still treating those companies most of the time just another case of very large private companies. Maybe we should think differently about them, because misinformation, disinformation are changing the very fabric of our democratic institutions.
Yeah. So, it's, I think that's self-evident, right? The fact of the matter is, it does change our democratic institutions. And building on what Lina said is, we care about antitrust because it helps us have more choice, and it helps us get lower priced products and services, and it protects innovation. But it goes to our democracy, right? A competitive economy and corporate actors can have a significant effect on what we see and what we think and how we act. And that goes to the heart of our democratic ideals. It goes to the heart of our freedom. The flow of information and accuracy of information is key to the political discourse, and it's the beating heart of our democratic process. And so we have to make sure that we are fighting to preserve that. And to the extent that companies who have outsized influence because of concentrated power, and they're maintaining that influence and that power through anti-competitive means, then it's all the more important that we act, because it's not just dollars and cents that's at stake. It's our very democracy and our very freedom.
So let's talk about a little bit. You said you want to stay in your lane. So let's talk about the antitrust toolbox. So big tech and democracy. Which tools are available at your disposal at the FTC and at the DOJ to protect democracy?
So look, I'll just say, to the extent that the news and media ecosystem and the free flow of information deeply affect democracy, I think some of the cases, especially that the DOJ has filed, are absolutely critical to that. I think we've seen over the years how the consolidation that we've seen in digital ad tools, the way that we now have a handful of gatekeepers that often end up controlling dissemination of news and information, bear directly on democratic values. And so the lawsuits that we've seen filed that are addressing some of those problems are key. I think stepping back, though, there's a deeper connection here between some of the threats that come from consolidated power, including in digital markets, and our democracy. And one of those major threats is the way that consolidation allows the exercise of arbitrary power, and the way that the exercise of arbitrary power can also enable coercion. It can enable gatekeepers to dictate terms, to bully people, to call all the shots. And for most people, their experience with power in their day-to-day lives is not with their elective representative. They experience power in their commercial transactions, in their economic transactions. And so if you're a small business whose livelihood depends on whether one of these gatekeepers, what they think of you on any given day, and if in order to succeed, you have to bow down to whatever dictates of that gatekeeper, that's going to create a very different experience of liberty, right? If you feel coerced in your day-to-day life, it's difficult to really feel free. And so that's how, at a more fundamental level, I see the work that the FTC does as really contributing to real liberty and real democracy, to make sure that we have an economy and markets where people can actually exercise choice, where people can actually exercise autonomy and self-determination, rather than just be coerced and bullied and pushed around.
Yeah, let me add on that, because I think it's such an important point, and it's something that it's easy to lose sight of. But the one thing that I think you're probably sensing throughout this discussion, and Lina hit it on it so eloquently earlier, is the impact on real people. I'm a lawyer and I have a client. My client is the public, but we can't understand the needs of our client unless we engage. And so I want to give you a couple of examples, and I think it illustrates how it really goes to our fundamental freedoms. I recently had the opportunity to sit around the table with family farmers in a rural community, and talk to people who've had farms in their lives, in their families for decades, generations. And around the table, we had the local bookstore owner and the local pharmacist, a local hospital worker. And what you realize is that the destruction of the family farm not only destroys that business, but it destroys the rural community. And this is affecting the livelihoods, the lives of real people. And they get it. And the words they use to describe it are profound and they're sophisticated, but they're real. Similarly, just earlier this week, I had a conversation with emergency room physicians talking about how concentration of power has impacted their ability to save lives in the ER, and how concerned they are about the ability to care for their patients at the time when patients and families most need them. I need them most. And that's real. And so, and they're not talking about it in this abstract way. They're saying that concentration of power, abuse of monopoly position, acquisitions have made it worse. And so this goes to the foundation of our very freedom and our very way of life. And if we don't protect that, then we are not adequately protecting our clients as lawyers.
Okay, so while both of you were clearly able to change the enforcement of antitrust in the last 2 or 3 years, Congress here in the US had very limited successes on this front. Perhaps Europe is leading now again with the DSA, while here Congress basically buried the bills that were supposed to rein in the power of big tech. What do you think is missing to have real partisan support for those antitrust bills?
I'll say as a general matter, I've been really struck time and time again by the degree of bipartisan concern about monopolization in our economy. I've had the chance to testify before Congress a few times, and each time I'm just struck by the way that folks across the aisle will share how concerned they are about how, for example, their local communities are being hollowed out, how local pharmacists, how local grocers can't get a fair shake, not because customers don't love their services, but because there are gatekeepers or firms with outsized power that are messing them around, that are discriminating against them. We hear a lot of concern about, outsized power, yes, in digital markets, but it's also across healthcare, where we see bipartisan investigations right now into the role of private equity in healthcare. We see bipartisan investigations into the role of pharmacy benefit managers, bipartisan investigations into consolidation in agriculture. And so, it's to a striking degree, given today's politics, think we see just an enormous amount of bipartisan concern. Both of our agencies have filed lawsuits with bipartisan coalition of state AGs. And so I think the essential ingredients are there. And, we're all waiting to see what comes out legislatively of Congress.
Yeah, I mean, I think we have to respect the role of Congress to write the law, and we're law enforcers. But my experience has been the same as Lina's, which is that this is not the concerns around competition and concentration of power transcend political boundaries. There are folks across the entire political continuum who express not just interest but desire for more enforcement, who think that these are issues that go to the heart of our very existence as a nation, and that we need to be vigilant in enforcing the antitrust laws.
So the reason I raise the question, bring into the fold the question of Congress action, is that in the last 2 or 3 years, whether you liked it or not, both of you have to become experts on the questions of platforms and technology. And my question is that, do you feel that bringing more competition to big tech, okay, and you're trying to do it with various lawsuits, would actually solve the inherent motive of those players to design algorithms that are more addictive and therefore more toxic, divisive, and polarizing? Because this is basically the context, the world in which we live in today. So is competition really the solution, or we need to Congress to act?
So we're competition enforcers, so those are the tools that we have. But historically, there's no question that competition and antitrust have just been one set of tools in a broader toolbox that include things like public utility tools, that include things like public options. Historically, there's been a first-order question about whether competition is really going to be enough to discipline market power or monopoly power. And there's a long tradition of, in certain sectors, be it in railroads or telecom, recognizing that these are network industries and that there are going to be a special set of tools and principles that we need to apply, be it things like common carriage and non-discrimination, be it things like mandated interoperability, be it things like structural separations or quarantines, because sometimes your networks play such a critical role that you can't allow their incentives to be corrupted through certain forms of vertical integration. And so that's a set of tools that goes back over a century. I think what happened was, as we saw a lot of deregulation starting in the 70s and onwards, a lot of that toolkit was somewhat forgotten. And so even if you just look at, law school curricula through the 70s and even into the 80s, there was a course called Regulated Industries that actually taught all of these different policy tools. And people like Stephen Breyer, cut their teeth on learning about that toolkit alongside competition and antitrust. For the last couple of decades, that's not even been a law school class that's taught anymore. And, for the vast overwhelming majority of law students, they've not even had an opportunity to learn about that toolkit in an integrated way. You might kind of encounter it in, banking law or in communications law, but the idea that there is a coherent and integrated set of tools that we've historically applied in markets that are networked, that have certain types of networked features, there was kind of a great forgetting that happened. And now we're at the beginning of rehabilitating that. some of that's happening in classrooms and textbooks. Some of that's happening quite organically. The Ohio Attorney General has brought a case kind of invoking common carrier and how it applies to some of these modern day tech platforms. So I think, we're still at a bit of a nascent stage, but even some of the bills that Congress has introduced reflect some of these principles. So, we're limited in some ways by the tools that we have, but one thing that's been really important to me at the FTC is not to be kind of arrogant with regards to the role of competition. There have been periods in the past where, enforcers have filed amicus briefs saying that gig drivers trying to organize are violating antitrust laws, even though it's pretty clear that Congress sought to exempt labor and labor organizing from antitrust prosecution. And so, I'm vigorously focused on enforcing the laws that Congress has given us, but making sure that we are not being, we're not exaggerating the role that the tools we have.
Can we envision a situation where, as part of a remedy or a settlement or something like that, in one of the big tech lawsuits and trials, we're going to see you intervening in the algorithm of big tech, banning some kind of behavior?
I can't talk about ongoing litigation, but I think it's important that if we're going to have remedies in antitrust cases, that those remedies are effective, that they're forward-looking, and they focus on promoting and restoring healthy competition. And so, I think we are both of our agencies are litigating, cases that have major significance involving companies with significant reach and influence. And I think both agencies are pursuing those cases in order to obtain meaningful relief, and relief that does not allow the same anti-competitive practices and gatekeeping power that was used to violate the law to reemerge. And so I think we have to look ahead, and to the extent that data, algorithms, and other technology tools factor into how those products are made, built, and delivered, it's certainly relevant to the conversation. And I think, AI is an example where, it is, we are looking down the road, and we are seeing the dawn of new technological innovations, some of which are really exciting, but a lot of those innovations are built on data sets that were consolidated in the current environment. And I think we have to be mindful of that.
One of the core principles that we apply to our work is not just understanding the business practices, but also understanding the business incentives that are driving those practices. And so in digital markets in particular, we've been very focused on understanding the ways that, for example, behavioral ad-based business models can drive a certain set of incentives when it comes to trying to maximize engagement on the platform, incentivizing surveillance of people and endless data collection. And understanding those incentives is key when you're trying to design effective remedies. And so, for example, in our consumer protection and privacy work, one remedy that's been central is when there is data that has been unlawfully collected, a core part of the remedy has to be not just deletion of the data, but also deletion of any algorithms or models that were trained on that unlawfully gotten data. Because if you're just focused on things like fines, you can see how illegally collecting data could just be a cost of doing business, because it could end up being commercially valuable enough to do so unless you're actually being forced to, effectively get rid of the unlawfully gained commercial value.
And you feel that the FTC has authority on looking only on the advertising side of the platforms, because the same data and the same questions about privacy and how we are targeted is also used in the newsfeed, in the organic part of the platforms. And one can argue that those are much more powerful in influencing public discourse than the advertising part?
Pass.
Okay. All right. Lina, you want to pass too?
I think so.
Okay. All right. So I want to continue. Jonathan, you introduced to the conversation AI. So are we looking actually into a world that Meta, Google, Microsoft, and Amazon, perhaps also Apple, take over AI? Is this dangerous? Is this inevitable? And what can you do?
How much time do you have?
2 or 3 hours. You have a flight. I know when your flight is.
Yeah. So I'll start at a pretty high altitude here, just because of this is a meaty subject. But first, I think it's important not to talk about AI as if it's just this one single technology. There are lots of different kinds of machine learning and algorithmic-based technologies, and they serve different purposes and they involve different data sets. And it's going to become, and it is becoming, a common across so many different industries and affecting so many different people. And so we need to be thoughtful about how we take our mission, which is to enforce the antitrust laws, and apply it in a meaningful, impactful way as all of these different technologies emerge. I think we also have to understand what makes these technologies run, and what are the characteristics that can lead to anti-competitive bottlenecks and gatekeepers and power. Data is one of the most important elements or ingredients to these machine learning and AI-like tools. And to the extent that, as I mentioned before, data has been aggregated or resides in the hands of a small few, then that may become the high water mark for competition, because the barriers to entry and scale and access to these key ingredients is limited to a small number of players. And so I think there needs to be a significant degree of urgency and attentiveness as we think about the implications for these new technologies. And it starts with making sure we understand how they work, and in making sure that we are addressing problems as quickly and as definitively as we can.
Lina, you want to chime in on the AI question?
I would just echo a lot of that. I mean, we're very focused on looking across the stack from, the chips to the cloud to the foundation model to the applications, understanding the economic properties of each one, understanding if there are already certain types of bottlenecks or choke points emerging. If so, why? Some of these, bottlenecks may be occurring for more organic reasons. Some of them may be occurring for reasons that implicate the antitrust laws. Even if you have bottlenecks that were not unlawfully obtained, are you exploiting those bottlenecks in ways that could extend or maintain your monopolies? So these are, some of the questions that we're focused on. We are, scrutinizing some of the investments and partnerships that we've seen underway, in part to try to ensure they're not a way to sidestep merger review. And so a lot of times with these technological inflection points, you see some of the tactics change slightly, but at the end of the day, there is a core monopoly playbook. And so we just need to make sure that we're fully understanding what that iteration will look like in the context of this new technology.
So Lina, recently I read that at another event, at a Remedy Fest, you used Ronald Reagan's famous quote about the most terrifying words, "I'm from the government and I'm here to help." And you said, the most terrifying words in the tech world are, "I'm from the App Store developer support team and your application has been rejected." That's true, I'm quoting you correctly?
That's right.
Yeah, so do you think that perhaps this goes to our conversation that today the most terrifying words are, "I'm from big tech and I'm here to democratize your country"?
Look, what my comment was intended to surface was the recognition that concentration of private power can undermine people's liberties in all sorts of fundamental ways, much in the same way that outsized and unchecked government power can. And that's an understanding that goes all the way back to the foundation of our anti-monopoly laws and tradition. And it's one that folks across the country, across parties are re-recognizing.
So I have a question for both of you. So clearly you have made tremendous progress when it comes to enforcement of antitrust and big tech. But when both of you assumed office 2.5 years ago, the combined market cap of the large big tech firm was $7 trillion. And today it's more than $10 trillion. And that has to do with the question is, are we moving, you are moving fast, but is it fast enough? And when you look at the S&P in the last 12 months, we see that much of the return has to do with those 5 large companies. And the question is, do you think that the market is signaling something to us? The fact that they are now $10 trillion companies. Is it more innovation and real growth, or is it more about their obtaining more market power?
We have to start with we follow the facts and the law. And the end of the day, we're law enforcement agencies. And so we look at conduct. We determine if that conduct violates the law, and if it does, and we believe we have the proper basis to bring a case, we bring it. And I think I think this discussion has helped animate some important principles. There's one question I think these often get conflated, and I think it can be confusing, which is, why do we have antitrust laws? Why do we care about competition? Why do we care about competition policy? Why do we want to enforce the law? Why do we care about or think that there's a risk of under-enforcement? And I think that goes to the earlier part of our conversation, because it results in risks. Those risks might be economic risks. They might be risks to our very freedom. I think that is an important conversation to have. There's a separate conversation, which is somebody engaging in conduct or practices that violates the law, and is it actionable? And I think both are important to have, but they're related, but they're also two distinct questions.
The other thing I'd note is, it's important to try to recall that we can't fully imagine what the counterfactual would have been in a more permissive environment, right? And to underscore a point Jonathan made earlier, deterrence here is key. And as law enforcers, deterrence is a key goal. We see quite routinely, prominent bankers, deal lawyers saying very openly that, as recently as several years ago, when thinking about deal making, antitrust risk was considered at the very end of the process, if at all. And now antitrust risk is front and center from day one. For a law enforcement perspective, that's just a huge win.
I want to point something out, just an observation as Lina was talking, because it was getting... I think it also underscores the importance of a whole of government approach and the importance of alignment between our two agencies. And so the effect of that deterrence and the effect of enforcement is exponentially greater when it is done with a unified vision of policy, a unified vision of mission. And I think the presence of a strong FTC makes the DOJ antitrust division more effective, and I'm hopeful that the presence of an effective, strong DOJ antitrust division makes the FTC more effective. I think together it is so much more meaningful and impactful than each of us independently.
So before we move to some Q&As from the audience, let's briefly talk about inflation, cost of living. So cost of living is, of course, skyrocketing. Almost everything is more expensive today. What's your position? What's your stand? What's your perspective on this debate? Is it inflation, like a monetary phenomena, or is it due to market power of so many monopolies, oligopolies, and so on?
Look, I think it's a really important question, and it's actually been really striking to me to see how just the asking of this question sometimes provokes a very emotional response. And, I think we have to follow the facts and look at the data. And I think we've seen over the last few years that, prices shot up during the pandemic, in part because of the supply chain disruptions. Even as some of those supply chain disruptions have eased, some of those prices have stayed high. And it's important to try to interrogate why that is. From a, competition perspective, we can imagine that a environment of inflation could give cover to companies to either maintain higher prices or potentially collude. We've also seen how consolidated supply chains can heighten the risk of those types of price shocks because a single crash or a single disaster can have such outsized ramifications. The FTC also, a couple of years ago, initiated a study into supply chain disruptions within grocery. And we recently published some of our findings, one of which was that during the pandemic, larger retailers were able to use their clout and their power to demand preferential supply from suppliers in a way that disadvantaged independent grocers and smaller grocers. And so even there, we saw how muscle and power gave certain entities a leg up. But I've been, very interested in the scholarship and the research that has been taking a more rigorous approach to this question in a more open-minded, curious way, because I think as policymakers, we really owe it to the public to make sure we're actually following the facts rather than, falling back on some of the kind of derogatory statements that we've seen about just even asking the question. So, I think just getting beyond emotion and thinking about this in a more reasoned way is going to be key.
Yeah, I mean, it makes me scratch my head sometimes because, and I'll, one of the debates, including at this conference, going back to the original incarnation and since, has been, one side saying that antitrust is about a whole wide set of values, including price, but not limited to price. And then another side saying we should just care about output and price. Okay, so both sides should agree that if there's a monopoly or a concentration of power, that could result in a higher price. And so, how it intersects with inflation, I'll leave that to others to untangle. But in an inflationary environment where people are concerned about higher prices, absolutely we should be concerned about competition. I think that's probably the one thing we should all agree on.
So you're blaming Chicago school for the inflation?
That's what you said just now? The new Chicago school, the old Chicago school.
Okay. So let's take questions from the audience. Yes, please, sir. Mm-hmm.
Chairwoman Khan, Chairwoman Khan, I'm one of your many right of center admirers. And I'm someone who talks about kind of corporate power, but also deals with it as the proprietor of a small magazine. It seemed to me that in the kind of 2020 around the election and the sort of Hunter Biden laptop story, and I was at the New York Post at the time, there was a great deal of bipartisan interest, or at least especially on the right, for like various forms of reform of reining in big tech power. Since then, the energy has died down. I think many on the right have made the mistake to think, well, one of our own has Twitter, so we're good on that, and have stopped. But there are elements of kind of corporate power involved, or market power involved, kind of translating into conditioned power, in the sense that big tech can shape how we think using its market power. So, for example, the fact that a lot of the algorithms just in general sort of derogate links, anything that has links, but especially if it's a link to a news story, that's very bad for me and for everyone else here who wants to promote a story. How is that not a competition issue? And it's not just like Zuckerberg, it's not just Elon, all of them. It's now kind of well known that they derogate links, which and it adds to the fact that they're often on both sides of digital ad markets, et cetera, et cetera. It's one more way that they act anti-competitively. So, like, is that something FTC can address? Save my business.
we always look at the specific facts and are really interested in understanding, what are the implications of some of these decisions. I think historically we've all seen how concentrating that decision making, especially in areas that affect news, the dissemination of information is really critical. So we take that seriously.
Yeah.
How, if at all, are your agencies preparing for the possibility of the Supreme Court moving away from the Chevron doctrine?
So, we're following all the developments in the courts closely, including the Loper case and the implications there. The FTC does do rulemaking, both on the consumer protection side as well on the competition side. The competition side, we do the rulemaking pursuant to the Administrative Procedure Act. And so there in particular, any, different outcome there would affect us. And so we'll look closely at it and follow the court.
Filippo?
I wanted to ask a question about litigation strategy, right? Because you have different powers in terms of, in a way, evading a little bit the judiciary that's still antagonistic with antitrust enforcement to a certain degree. You can bring jury trials, or you can use administrative law judges. So how do you think about the allocation of cases between like a traditional judge-decided case versus like administrative law judge or a jury trial? Like, what was the strategy behind one or another case? I'd love to hear any thoughts you have on that.
Yeah, I think we need to think of ourselves as litigators and law enforcers. And so we bring a case, we bring to win. We bring because we believe we're right on the facts and the law. But I think, those are, litigation, there's a lot of strategy and strategizing. But at the end of the day, it's about telling a story, and it's convincing a fact finder. It's convincing a judge or a jury. And I think, understanding explaining why something is important, explaining why conduct is wrong, and explaining why somebody should care, all go to the very heart of any litigation, regardless of where you bring it.
But there are certain types of conduct that are more amenable to juries than others that would make you want to bring like a tech jury case or not. So how do you see this? Like, it's like, this is easy to explain. This is so complicated.
Yeah, listen, I think that, I've thought a lot about this issue, as you might imagine, and there's a long history of bringing complicated issues, whether it's securities fraud or commodities manipulation, and a wide range of industries and disciplines to juries. And part of the exercise when you bring a case before a jury is you have to make it digestible, and you have to explain the difference between right and wrong. That actually can be a very valuable exercise because it helps you distill the essence of your case down to its core elements, and it helps force you to explain something in a way that non-experts can understand. And I think, again, going back to the theme we were discussing earlier, part of our approach to antitrust is to make it more about people. It's the people's law. And so antitrust was never meant to be too complex for a jury. And so in my view, we should always be able to make a case digestible to a jury. And that is on us as an agency to make the material accessible. But antitrust was never supposed to have experts and expert courts. It was supposed to have the antitrust laws, the Sherman Act, the Clayton Act. Cases were supposed to be brought, at least by the Department of Justice, before general courts and juries. And so if it's too complicated for a judge or a jury to understand, then perhaps we're making it too complicated.
Teams?
Thank you. At the opening panel today, Tomasco, who is still here, I think, produced a finding where he found that competition enforcement increased productivity and economic growth, if I'm not mistaken, but that there's just not enough of it. And that and he also pointed out later that the resources given to the antitrust agencies and also the FTC are a fraction, and FTC also being consumer protection, are a fraction of other economic actors, say Treasury or the Federal Reserve or something like that. So I wonder, another third point, I'll say Thurman Arnold back in the day, he was bringing, I don't know, hundreds of cases, much higher volume. And people say you bring high volume, but Thurman Arnold, the volume is extraordinary. So I was wondering, in an ideal world, what full level of resources would it take to have the kind of antitrust enforcement you think would really maximize the productivity possibilities of a strong competition policy? I don't even know, but it would obviously be more than that. But is there some limit, or would you agree with me that we're grossly underfunding the antitrust enforcement side of our government?
I would overwhelmingly agree, and I don't even know that there's a natural ceiling that comes to mind there.
Yeah, I concur. I will point out that sitting here today, we still have far fewer people at the Antitrust Division than we had in 1979. Let that sink in. And that's against the backdrop of a much more complicated and a much more challenging economy and a litigation environment where we have to consume massive amounts of data and documents in order to bring even the most basic of cases. So all of that is to say thank you for the question.
I think Tim is arranging a crowdfunding for you for the two agencies.
Go fund me.
Yeah. So I will just end with one note. Perhaps some of you have seen the Lina or Jon Stewart 2 weeks ago, and during that interview, Stewart revealed for the first time that actually when he worked for Apple, he wanted to have Lina on the show, and the Apple people told him, no, don't bring Lina. So I think that pretty soon, it's Apple, and then it's going to be not on YouTube, and that or not on Meta, and pretty soon they're going to kick you out from all the platforms. So Luigi and I want to commit that on this platform you will always be welcomed and invited. Thank you, guys.